All right. Welcome, everybody, to our next episode of the Litigators Network. Really excited today. We have an amazing attorney with us, who's a guru and authority on all things bad faith. And I want to introduce Kristin Hobbs. Thank you so much for being here with us today.
Well, thank you for having me, Kenny. And it's nice to be introduced as a guru. I don't know that I've necessarily been practicing long enough for that, but I certainly appreciate it. And I'm excited, as always, to talk about insurance issues.
Yeah, and I think thank you. That's just you being modest. You practiced for a long time. You have your own practice now. For a long time, you were with Shernoff Bidart Echeverria as well, who does a lot of and is well known for insurance bad faith. You have your own practice now, which is amazing. I love that. And yeah, so thank you for being with us today. And I just kind of want to get into it, right? As PI attorneys, as plaintiff attorneys who do personal injury, oftentimes we hear about popping the policy. We know that we have to do that on our case, and that's kind of where we want to get to. And we hope, wish for the day where they don't accept the reasonable demand so that we can get more than whatever the limits are, right? But maybe we don't understand the intricacies of it, right? Or maybe we've been practicing for a while and we've heard about popping the policy, but we don't know what actually happens after that or why we're doing what we're doing. And so it's great to have you on today to talk to us a little bit about what is insurance bad faith, kind of what's the background on this and why it's so important, the mechanics of it. So maybe can we get started, Kristin, with what is insurance bad faith?
Sure. So kind of going back to like the very beginning, which I think is super important so that like we get like a foundational understanding of insurance. So at its very core, there could be two different types of insurance. There's first party, which is where you're the one who has the policy. It's your own insurance company, maybe like your homeowner's insurance policy or your auto insurance company, but you're the one who's insured under it. So we call that first party because that's your own insurance company. In that sort of situation, the insurance company owes you the duty because you're the insured. You're the one with the relationship with the insurance company. What we as plaintiff attorneys more often come across is the third party context, which is when you're suing someone, that person that you're suing, their insurance company is the one who is stepping up to defend them and to kind of indemnify them or settle the claim with you. And so just kind of taking a step back, I often get calls from people off the street who are mad because, they're dealing with this adjuster and the adjuster's not listening to them. Maybe the adjuster's lowballing them and they want to sue them for bad faith. So it's like, I get it. Like adjusters, some can be okay, but most of them can be pretty terrible to deal with because this is their job. Their job isn't to pay out your claim.
Sure.
And so I have to kind of go back to the basics and tell them there's nothing that you can really do to speed up that process other than put pressure on the fact that you want to sue the other driver or you want to settle this claim with the other driver because the insurance company is protecting that driver. They're not protecting you. You have no rights against them. And so I really kind of have to just go back to the basics and explain that different relationshap. And so in that kind of just basic setting, what you really need to do is put pressure and make the other driver's life uncomfortable. I'm going to sue you or I'm going to make these claims against you. And that's what makes them turn around to their insurance company and say, what the heck? Like, I thought I had you here to protect me. Why aren't you doing this? And so that's more the third party context that we kind of come across more often. I think I got off topic, but I think I
No, you know what, Kristin, no, and thank you, because that is that background, that context that is necessary, right, to understand then the jumping off point for insurance bad faith. So thank you so much for that, because that's helpful. And it's so funny because so often, as attorneys, first year, second years, whatever, you sort of get thrown into the line of fire and nobody explains something as basic, as seemingly basic as this, right? But it's so critical as a building block to what comes next, right? So thank you so much for explaining that. And so in that context, then insurance bad faith, how does that sort of develop, and why is there a cause of action, and how do we get started there?
Yeah. So going back like a number of years, and it's kind of exciting. So you mentioned my background at Shernoff, and wonderful firm. I'm still great friends with them. We still work on cases together. But Bill Shernoff really was the leader in developing this tort. This type of situation never existed. So it used to be that if you sued an insurance company for something and the insurance company's position turned out to be wrong, all they owed for was the claim that they would have had to pay out in the first place. And so there was really no incentive for insurance companies to like settle claims or to engage in good faith. And so Bill came along and had this case that actually was in our little Pomona Superior Courthouse in Egan versus Mutual of Omaha that went up to the California Supreme Court. And ultimately, they found that that situation isn't right, that there should be some sort of penalty against the insurance company if they act unreasonably. And so unreasonably is really important because that's like fast forwarding to Pinto, which I'm sure we'll talk about in a second.
That's it. Sure.
Yeah, super important. But so the California Supreme Court found that, hey, if an insurance company acts unreasonably, that is a tortious act. That brings it into the tort field. That's not just a breach of contract. And then they can be responsible for more damages, attorney's fees, prejudgment interest, emotional distress if you're dealing with a person. And so that's what developed this tort back in the 70s in our little Inland Empire area, even though I guess Pomona is technically LA County. I consider it Inland Empire because we're so close. But that's really where this tort developed. And so, well, I guess I'll give it back to you.
Keep going. No, keep going. That's great. So this is where it develops. And maybe as we're sort of creating a distinction between everything, you mentioned Pinto, right? There's now what's considered before Pinto and then everything post Pinto, right? So starting with everything before this recent Pinto case, what is it that needed to be shown in order to establish a bad faith claim or case?
Got it. So without getting into like the nitty gritty of like what happened since Egan, the law developed that if in a third party context, if there is a reasonable offer to settle, that for whatever reason, the insurance company doesn't agree to settle. So they say no, they reject that policy limit demand or that demand within limits, which I think is important. It doesn't have to be for the whole policy limits. It can just be for an amount within.
And can I pause you there for a second, Kristin, because I think that's really important and most people don't know. I certainly did when I got started, right? Because you think that you have to make the demand for the policy limits. So can you explain that? So it's not just that.
It's not just that. So anytime there is a demand within limits, there could be $100,000 policy and you can offer to settle for $15,000. So let me just talk about the auto, the auto accident industry, because that's like what a lot of us personal injury attorneys deal with. So you get this claim and you make a claim with the third party, insurance company. And you want to settle the claim and your client comes to you and they have these medical bills and you want to settle it. So you figure out that the limits are, we'll just say $100,000 and you want to settle it. Remember, the insurance company doesn't have a duty to your client, the injured party. They only have a duty to their insured, the person that you're making the claim against and will eventually or are suing. So you get the $100,000 policy limits and your client's injuries are way more than that. So you make a demand on them for the policy limits and you say, hey, insurance company, I want to settle for the policy limits or for the $100,000. Here's all of our clients' medical bills. Here's all of their damages. Here's all the reasons why you need to settle with us for the $100,000. Their damages are way more.
Right.
That then shifts the burden to the insurance company to look at it and evaluate that offer to settle. They have a duty to investigate that we all know, to look into those injuries and see, does it warrant paying the policy limits? And if it does, they have to settle. And so the law before Pinto was, if there was a reasonable offer to settle that the insurance company rejects for whatever reason, maybe they don't think it's worth it. Maybe there's a coverage dispute, which is a whole nother issue. But for whatever reason, they reject that offer to settle. And then later on, you get a judgment above the amount of that policy limit. You can then turn around and sue get an assignment. I'll go through that in a second, but sue the insurance company for bad faith. You can open that policy. And the reason why the law is that is because now the insured, the person who you're suing, the person who the insurance company was there to protect, they're now exposed personally. You had this they had this $100,000 policy limit, but now they have a judgment against them for $200,000. Well, the insurance company is only going to pay $100,000. So now they're going to have to come up with that extra $100,000. And so the law developed saying that's not fair, because under your insurance policy, the insurance company is the only one who has the right to settle. The insured can say, I really, really want you to settle this case. I'm really scared about this. I don't like litigation. I want it to go away. I want to be able to sleep at night. And the insurance company can say, we don't care. Like, we don't think it's worth that. We're not going to pay it. And so the insured, the person who has the policy, the one who's being sued, they have no rights in that situation. And so the California Supreme Court said that's just not fair. And so when the insurance company is gambling that they're going to beat that offer and get in, settle the case or get a judgment below the policy limits, that's a gamble that they are taking on. And so if they are wrong and you get a judgment above the policy limits, they are the ones who need to bear that burden. So I say all that to just kind of set the table, because your question is a valid one, which is, so when you're making a demand, does it need to be for the full policy limits? And it doesn't. It just needs to be for within the policy limits. So if you have a $100,000 policy, you can say, I will settle with you for $15,000. And if you're okay with settling for $15,000, then it makes sense to do so. And if the insurance company says no, you have made that demand within limits. And if you get a judgment then above the policy limits, you can argue that the policy is open.
Sure. No, thank you for that. That is an amazing explanation of it. I think in a very seamless sort of manner that they're easy to understand and digest here. In your experience throughout your career, it is something that you've dealt with a lot. I'm not going to say exclusively, but you've done a lot of these sort of cases. You've tried many of these cases. You've hit, 7-figure, 8-figure cases on this stuff. And so like you're really well versed and experienced on this. How often have you, or what sort of factors in what types of cases have you seen where insurance companies deny these types of cases? Is that something that they, when they've denied a reasonable demand, how often does that happen? Is maybe an unfair question, but what types of cases have you seen it pop up quite frequently?
So that's like a seamless question to like get into this whole Pinto issue. So before Pinto, and I don't really want to necessarily dive into the facts of Pinto because we're limited on time. And I'll just say, for the plaintiff's perspective, bad facts make bad law. And so that's maybe a case that should have never been appealed, even though when I was at Shernoff, we worked on the appeal. But so it really is just like a really tough, nuanced, factual situation. But before Pinto, the way the jury instructions were written and the way that we from the plaintiff side argued that the case in the third party context, this failure to settle, needed to be argued was there a reasonable offer to settle? And if we can establish that there was a reasonable offer to settle that was not accepted, then the policy is open. So the entire analysis was focused on the reasonableness of the offer. And that's all that we argued you had to look at. And frankly, that's all the jury instructions, KC 2334, looked at also. There was no analysis of whether the insurance company acted unreasonably, because from our perspective, if there was a reasonable offer to settle, the only reasonable means of dispensing with that reasonable offer is to accept it.
Right.
I mean, to me, that made perfect sense.
It makes sense, right? From a public policy perspective as well, right? If you deny a reasonable settlement demand, then you've acted unreasonably, quote unquote, period. Right. Yeah.
Period. Like, why do you even need to look at what the insurance company did or didn't do? Well, the insurance company always argued the other side and said, no, you need to show we also acted unreasonably. That's like a tenant in bad faith. And it's true in first party context, but not necessarily in third party context. And so there was never really a case that directly decided that issue. And so if the courts just went along with straight how the jury instructions were worded, well, how KC 2334 was worded, we got from the plaintiff side, got our way. But sometimes the defense could argue their way and like get, another special instruction in there. So then Pinto came along, and the court, to their credit, actually went through and analyzed all of the cases in this area of the duty to settle in the third party context. And they ultimately decided that you have to not only show that you made a reasonable offer, but also that the insurance company acted unreasonably. So now there's two prongs to what, and that's now in the jury instruction. And so now there's two prongs to what needs to be shown. You need a reasonable offer, and you also need to show that the insurance company's response to that offer was unreasonable. And so that's been the case since Pinto.
Okay.
So to get to your question on like what makes an attractive like bad faith case, especially from the plaintiff side, even before Pinto, I never really liked those gotcha cases. Those cases where it's like, we want to set up the insurance company, where it's like, you have 15 days to accept this.
Right.
Acceptance needs to be emailed to us at 4:57 p.m. on the dot. You need to have this super specific declaration, that if it doesn't say all these things, then we're going to reject it. And like, it just had all of these like super specific requirements. And if they weren't complied with to the T, even if the insurance company said, all right, here, we're tendering, here's the release, here's all the stuff, and it looks like it complies with it, and then they turn around and say, well, you didn't do like this thing.
Right.
I never liked those cases, because even though under contract law, which is what we would argue, acceptance needs to mirror the offer, and so there needs to be this kind of perfect acceptance. It just never played well to a jury, because juries are sitting there and they're hearing all these facts and they're like, so you mean to tell me they wanted to accept this and they didn't do this one thing, which they kind of did, and now you want them to be liable for like $3 million? And so it's just really difficult for a jury to kind of wrap their mind around. And so I just never really liked those cases, especially in federal court. The federal judges were basically like juries where they were like, we're not buying that. And you go to federal judge, you're kind of stuck with it, which is fine. And so Pinto has really made those gotcha cases even more unattractive, because then you also now need to look like, did what the insurance company do, was it really unreasonable when they're trying to comply, when they're writing you back and trying to do all these things you asked, and even saying like, if we didn't do it right, please let us know, and then you didn't let them know. So it really just kind of makes those cases even less attractive.
Sure. Okay. And so before Pinto, we have this situation where all that's necessary is for there to be a reasonable settlement demand and a failure to accept it. And then post Pinto, now we have that, plus you have to show that they were unreasonable in their failure to accept the reasonable settlement demand.
Yes.
Okay. What has changed? What hasn't changed post Pinto in terms of evaluating a case, in terms of working up a case in this area?
Yeah. So good question. And as I kind of mentioned, so the types of cases that are now more attractive in this like third party settlement case are really like the valuation disputes, where you can show the insurance company had a lot of information to evaluate the extent of your client's injuries, or maybe the liability question, and they still turned around and said no. Those type of cases are still valuable bad faith cases, because the insurance company, a lot of times you have adjusters who have 100 claims on their desk, and they're just kind of looking through things maybe for 3 minutes and just not really spending the time that frankly they should on these more serious injury cases. And so really now when you're looking through a claim file, let's say fast forward to getting a bad faith case, you really need to spend more time on the claim file and more time developing the chronology about when did information supporting liability or damages come to play, and when did the insurance company get that information, or could they have known that information? And that whole chronology becomes incredibly important, because if you can show that, on such and such date, like the insurance company was provided information that your client, needed a surgery or was a surgical candidate, but they didn't really take that into consideration. And you look at the claim notes to see, okay, what analysis did they do? Did they just say, need surgery, didn't elevate it, didn't talk to their supervisor, didn't, send it out for a medical review? Then you can really show that they didn't really analyze that correctly. Another thing that is now, I think, so incredibly important are the claims manuals or the claims guidelines. In California, an insurance company is required to have written guidelines on the proper investigation and processing of claims. those written guidelines are a gold mine because it shows what they should do and all the steps they should take. And inevitably, there will be steps like this is what you do for a proper investigation. You look at this, you look at that. Any questions, you talk to your supervisor. And so you can really go through those guidelines and then look at the claim file to see what they should have done, which is in writing, and what they didn't do in this particular claim. And that's really clear. And it's a really easy way to show the jury, this is why we're here. If they would have just followed their own guidelines, we wouldn't be here because they would have arrived at the conclusion that we arrived at, which is our client's injuries were clearly worth more than the policy limits.
Yeah. I can see those as being really fun depots, really fun examinations, right?
Yeah. And actually, yeah, we, Ricardo and I, Echeverria, my former partner at Shernoff, we just finished trying a case up in Santa Clara where that was the highlight of our case. And oh my gosh, GEICO, they were fighting us tooth and nail to keep out the claims guidelines because they knew that it's just so easy for a jury to wrap their mind around, oh, okay, here's the standards, because juries don't know what a adjuster is supposed to do. Yeah. And you have, you're going to have your expert saying this is what an adjuster should do. They'll have their expert saying, well, this is what an adjuster should do. And we did that. And so when you have in black and white the claims guidelines, it's just like, oh, well, why don't we just read that? Like, why didn't you just do that? And so it played off really well in front of the jury.
Yeah. And yeah, for our viewers and listeners, I mean, if you have any questions in this area, if you need to have a case looked at, Kristin is the one to go to for this. And Kristin, can you share with us a little bit about that case? I know that's something recent. We chatted a little bit about that at our recent CAOIE party that we had. It was a huge verdict. I think it's something, not just to be proud of. I think it's something amazing, right? And spectacular. Can you share with us a little bit about that case? And it was a very difficult case. I remember reading the facts on it and talking to you about it and going, what? And you guys still hit for all of this? Like, that was amazing. Can you share with everybody about that case?
Yeah, thank you. And yeah, and I'll especially because it's so illustrative of kind of the whole process of these cases. And also kind of as a warning to plaintiff attorneys that if you're going to take on one of these cases, expect a very long timeline. Yeah. So that case, Selk versus GEICO, the accident happened in 2012, and we just tried it last year in 2023. So it was a long process. So in the underlying case, our client, Malti Selk, was riding a motorcycle down a highway when he got rear-ended. It was a chain accident, so 3 cars. He was the middle car in this chain car accident. He was rear-ended by a lady named Vanessa Tran. He flew up in the air after being hit because he's on a motorcycle and doesn't remember anything about how the accident happened. Tran wasn't looking when the accident happened, otherwise she would have seen the traffic was slowing. So she wasn't paying attention when the accident happened and didn't know how the accident happened. And the driver in front of her also wasn't entirely sure on how the accident happened. So an officer comes to the scene, does an investigation, and he ultimately concludes that Selk, the motorcyclist, rear-ended Miss Tran, who then rear-ended the first car. So he got the chain of events wrong. And our client couldn't remember. He didn't know what happened because he had broken basically every bone in his body. Yeah. So Tran was insured by GEICO. And Mr. Selk, he's a native of Germany. He doesn't have health insurance. Back in 2012, I think it was even before Obamacare, so he didn't need to have insurance. But he gets hit with this massive hospital bill. And he's looking at the damage on his bike, and he's just looking at it, and it's just completely crunched in the back. And the front doesn't have much damage. And he cannot figure out how he supposedly was the one who rear-ended Tran. Sure. And so he handwrites a letter to GEICO saying, I have all these medical bills. I need you to pay them. I have my bike. I don't think I rear-ended her. I think the police report is wrong. Please pay my bills. Please pay them in the next 30 days. Yeah. GEICO gets that letter within a day. They say, nope, we're not paying it. We're rejecting it. Turns out Tran had a $100,000 policy limit, which Mr. Selk didn't even know. His damages were, his medical bills alone were like $300,000. Clearly excessive. But they decided that she wasn't at fault for the accident. And so they rejected it. He goes out, gets an attorney who's looking at the damages and is like, I think you're right, Mr. Selk. Like, I don't see how this could have happened. Files a lawsuit. Now GEICO's doing the investigation. They hire an accident reconstructionist who goes out, looks at the vehicles, immediately is like, yeah, there's no way he rear-ended her. Like, so it was so obvious that the chain of events was wrong. And so GEICO's then like, oh, okay, now we'll pay her $100,000. But now Mr. Selk, who's now had to hire an attorney, is like, I'm not settling with you for $100,000. That's not enough to pay me. So they go forward, get a big verdict at trial, like with Selk against Tran. Then Tran, this is the assignment, which I know we won't get into, but then Tran gives Mr. Selk the rights to sue her insurance company, GEICO, for the judgment because she doesn't have millions of dollars to pay the judgment. So then we filed the case against GEICO. And the whole case was about GEICO's investigation. And in their claims manual, it says, you know, do investigations, hire experts if you need to, get photos, talk to people. And none of these steps they did. There was an independent witness who actually saw Selk being rear-ended. They never called him. And so just all of these steps of investigation that they should have done, they didn't do. And so their whole case was relying on the police report. They're like, well, look at the police report. Like, we just relied on that. And like, if the police came out and investigated and they said this is what happened, why isn't it reasonable that we rely on that? And so we were able to look at the claims guidelines and say, this is why it's not reasonable, because why are you telling your adjusters to do all these steps if you didn't actually want them to do that? So ultimately, the jury found that Mr. Selk's handwritten letter was a reasonable offer to settle and that GEICO acted unreasonably in responding to it.
Yeah, that's amazing. And thank you for sharing that. And I know that there are many other sort of like facts in there that made this case, you know, very complicated. So, you know, and can you tell us what was your guys' verdict?
Well, it was 6.9 million, which was the amount of the underlying judgment. But it's, yeah, there could be an appeal for attorney's fees and things like that.
Sure, yeah. Of course. No, that's amazing. And, you know, again, I think it shows what is sort of the result in these types of cases, right? You're working off of something that was a 100,000 policy limit that now is 6 million and up, right? And so thank you so much for showing that. Thank you for talking to us, Kristin, today about insurance bad faith. I think it was something that is very, very educational and also inspiring in what you've shared with your case as well, your trial. Thank you so much. I know it's going to be really helpful for everybody of all years of experience practicing. So thank you again, Kristin. And anybody who wants to, you know, reach out, Kristin, how can they get a hold of you?
Sure. So I'm at Hobbs Law Group, and you can always call us 626-782-4520. Or you can email me if you have any questions on policy limit demands. I'm always happy to look at them before they go out because it's always hard after the fact when I, you know, have things to nitpick, which is Kristin@HobbsLawGroup.com.
Awesome. And Kristin, one fun fact about you is that you and your husband practice law together, right?
We do. Yeah. He handles a lot of the personal injury and I do all the insurance stuff.
Yeah. No, that's awesome. Okay. Well, again, anybody who has any questions, and that's awesome that Kristin has offered to, you know, take a look at your demand letters before they get sent out. So, you know, reach out to Kristin. She's the one to reach out to. And in this area, again, Kristin, thank you so much for being here. And with that, everyone, thank you for your time. And we'll see you on the next episode of the Litigators Network.
Thanks, Kenny.